It's time for FLA Law, brought to you by the personal injury attorneys of Perinick, Caulfield, Averill, and Noyes. This hour will be informative, along with taking your questions and comments. Now, here are your hosts for today's show.
That's right. We are back live on the air with FLA Law Radio. And tonight we are in for a treat because we have a special guest with us. For all of our listeners who have been tuning in every Tuesday at the 5 o'clock hour, I want to go ahead and welcome you back again. For our new listeners, thank you for joining us. I'm going to give you the call-in number right away so that if you have any burning legal questions you've been holding on to since the last time we've been on the air, you can go ahead and give us a call tonight before I introduce my guest. That number is 727-441-3000. Again, that's 727-441-3000. That is going to be the number that you will call into tonight in order to get your questions answered by myself and my guest, who is here to answer your questions as well. Before I turn it over to my guest to introduce himself, I also want to let you know that we are streaming live on Facebook and YouTube this evening. Our Facebook account, if you have a Facebook social media account, you can find us at Perinick, Caulfield, Averill, and Noyes Injury Lawyers. Perinick is spelled P-E-R-E-N-I-C-H. Hopefully you can type that into your search bar on Facebook and find our live stream. We are actually live in the studio right now. So hopefully you can do that. If you don't want to call in and hear yourself on the radio, you can actually type right into the comment section. I'm looking right now, and I'll be able to read your questions out over the air, and Mark can answer those. So without further ado, I would like to introduce you to our senior partner at Perinick, Caulfield, Averill, and Noyes. He's here with us this evening for the hour-long legal show, and he's going to go ahead and introduce himself.
Jacqueline, thanks for hosting the show and having me out tonight.
Absolutely.
And I think the question begins, how is it that I'm in with this firm, and how did it start?
Yes.
And I was born in Clearwater many years ago, and in 1955, my father and another attorney started the law firm. And when they started the law firm, there were no attorneys that specialized in injury cases at all. Most of the people practicing law were not interested in representing people who got hurt and trying to help them get through their problems. And my dad and his partner had a different view of that. And so they started the firm, and they originally had a little office on Osceola, and then they had an office on South Fort Harrison, North Fort Harrison, which had previously been a fire station for the city of Clearwater.
Oh my goodness, didn't know that.
And so I remember as a kid, when they got that building, there was a hole in the ceiling with a pole that the firemen could slide down to jump in the fire truck and take off. And so I wound up getting involved in the practice of law when my father asked me to come work for him while I was still in college. And he said, there's two things I want you to do. He said, I want you to go out and take statements from witnesses, find out what they know.
Okay.
And then type up a transcript so I can see what the questions were and what you asked them.
Right.
He said, the other thing I want you to do is I want you to learn how to do legal research. So the second floor of that building was an entire library. And so he gave me assignments, and he never put a time limitation on how long I could spend researching things. And it turns out that some of the assignments were much more difficult than I had anticipated. And it was only until I was in law school that I realized that was a ridiculous assignment to give me. But I solved the problem with the case.
Right.
I overcame a defense in the case, and I think it made a big difference. And really what that instilled in me was dedication to help people. Take on these issues, figure out a way to bring justice back into their lives so they can go forward with their lives. And I've been practicing law 39 years. So next year will be 40. That's a long time.
That's an amazing feat.
I've had a lot of experience over the years representing some really nice people who unfortunately have had some very bad things happen to them.
Right.
And, particularly it's difficult in wrongful death cases, and particularly difficult when a child dies. It puts the parents through utter misery. So I've had those cases over the years. So in the beginning of my practice, I started out just doing mostly auto accident cases and then slip and fall cases. And I didn't really know that much medicine. But over time, you learn medicine because you're taking depositions of doctors. You've got to ask them intelligent questions.
Right.
And that was fine doing that for all the years that I did it. But frankly, what's happened in the last 10 years or so, maybe 15, I've been really specializing in doing medical malpractice cases.
Right.
And which I find them to be much more fascinating and more interesting.
Mm-hmm.
They're very complicated and they're very complex, and there's a lot of medicine you have to learn to be able to handle them.
Oh, yeah.
So people often say, well, what's the difference between just handling a regular auto accident case and medical malpractice cases? Well, the primary difference is that when you're trying a case before jurors, they all understand the basic rules of the road. Don't speed, don't drive drunk.
A lot of it's common knowledge. Yeah.
It's common knowledge,
Mm-hmm.
it's a way you learn to drive and the things you were taught and things you need to follow. And so you can just present the factual evidence to the jury and they can decide, was that person negligent? Did they do something they shouldn't have done or fail to do something they should have done?
Sure.
And a lot of motor vehicle accident cases occur when there's a rear-end collision.
Right.
Person stopped at a light or they're stopped waiting to make a left turn. Person behind them's not paying attention,
Mm-hmm.
realize it's too late and hits them.
Right.
But jurors can decide that pretty easy. That's not that difficult. But when it comes to medical malpractice cases, those are very expert intensive cases.
Right.
Because you have to hire medical doctors, nurses sometimes, radiologists to examine the medical information and to render an opinion as to what went wrong and why did it go wrong. So there's a standard of care in medicine that imposes upon healthcare providers minimum requirements of what they must do to provide proper care to patients.
Right.
And if they fail to do that and it results in a harm or injury to the patient or even death sometimes, then they can be held responsible for that. But they're complicated cases because they're not oftentimes they're not just a simple, I misread the CT scan. I had a case.
I think that is something that the public tends to misunderstand, right?
I had a case against a radiologist who misread a CT scan of a gentleman's liver. And I didn't know this, but he developed liver cancer.
Mm.
And there is a period of time in which he would have been able to have a kidney transplant.
Mm.
And I hired an oncologist out of California who told me, Florida is unique in the sense that there's a prevalence of kidneys available because of our no motorcycle helmet law.
Oh my God.
So a lot of people
Wow.
wearing in a motorcycle accident, they have head injuries, but their organs
Their
usually can be
liver and
harvested.
kidneys, yeah. Oh my
And
goodness.
so,
It's a bit morbid to think about.
it is a little bit morbid. You
Wow.
wouldn't think that would be the byproduct of that statute, but apparently it is indeed.
Right.
And I've seen some really terrible things happen. I remember early on with the firm that we had a case where a newborn had been born premature, and they put him in a heater
Mm-hmm.
crib, and it malfunctioned, and it literally cooked the poor child
Oh my God.
in front of their parents. Can you imagine?
Having two premature babies,
I
God.
couldn't imagine that. That's just
Wow.
horrendous. And then I had a case where two medical doctors were here in the state of Florida, husband and wife.
Mm-hmm.
And the wife woke up the first morning that they were there, and she was complaining of lower right quadrant pain, and her husband took her to the nearest emergency room.
Mm-hmm.
And they had two children, 6 and 8. And the hospital had a sign up that you're not allowed to come into the hospital with your children. So he took her there. He had to take the children back to the hotel where they had a room. And it turns out they did a CT scan and they said she's got an inflamed appendix and she's going to have emergency surgery.
Mm-hmm.
And so they did the surgery. She was put on the floor of the hospital about 12:30 a.m. that night. And during the night, her blood pressure kept going down and her heart rate kept going up.
Mm-hmm.
And so in the morning, she told the nurse, my blood pressure is too low. Something needs to be done. And it was really low.
Mm-hmm.
And the nurse just pretty much ignored that. They didn't appreciate that this could be a sign that she's bleeding internally, and it was.
Right.
And nothing was done, and she went into cardiac arrest. And she had to be withdrawn from life support at age 43 with two young kids.
Oh my goodness! Wow.
And you wouldn't think this would happen to doctors. I mean, we put a lot of faith in our physicians. I have a son who's a surgeon too. I mean, I don't relish bringing cases, but I can see the devastation that occurs because of it.
Exactly. And so some of these examples you just gave, they seem so clear that there was something wrong there. But I want to go back to the point that you made earlier, is that you have to have a medical expert in order to bring these claims. So no matter how clear it may seem or evident to you or I or even the general public, if we don't have an expert on our side, can that case still be brought?
No. So what the law has, we have some very specific procedural requirements in the medical malpractice law that says that before you can file a lawsuit against any medical provider, you have to have a comparable expert who can render an opinion that there's been a breach of the prevailing standard of care.
Mm-hmm.
They then have to sign an affidavit.
Wow.
And they have to be a qualified expert. And if they're from out of state, then they have to register with the Florida Department of Health to be able to give an opinion. And then we have to serve a notice of intent to notifying the doctor or the practice or the hospital of my client's intention to bring a claim for medical negligence. And that opens a 90-day window where they can then do informal discovery to try to sort through the case. And the reason that was suggested for that was that this would be a good way for possible defendants to try to get their cases resolved. And I will tell you that that hasn't helped one bit. I can tell you on one hand the number of medical malpractice cases that I have settled without filing a lawsuit. They're prone to be defended. The doctor doesn't agree. They hire another doctor who says this doctor didn't do anything wrong. Sure. And that starts the battle. And unlike other types of injury cases, you can have an auto case that might go 2 years in litigation, or it could be 3 years by the time you file your suit, whatever. But medical malpractice cases can go on for 6, 8 years. They can go on for a long time, and they're very labor intensive. Mm-hmm. It's not, I just took the deposition for half an hour of the eyewitness to the auto accident.
Right.
It's much more complicated.
Not quite the same. That's true.
So one of the things that I learned early on in the practice of law is that I no longer take depositions in medical malpractice cases unless I have a medical doctor sitting with me in the room.
Really? Wow.
Because I need to know if someone's going to try to snow me.
Yeah.
Think they can pull the wool over my eyes.
You've got your expert
right there.
Yeah. I didn't know that.
Yeah. And I think that's very unusual for attorneys doing that. I would be surprised any other attorneys do it all the time.
Right.
But as a matter of course, I do it. And I think it really helps the results that I'm able to achieve.
I would see how that would be the case. I think coming into it, the defense is probably shocked to see the doctor sitting there. Yeah.
I had another really tragic case, a young boy who was 9. He had some energy endurance issues. And so the cardiologist suggested that they replace his aortic valve. And they set that surgery up, and they planned to replace it with a metal mechanical valve. And instead of putting an aortic valve in the aortic position, they put in a mitral valve, which worked completely the opposite. So every time the left ventricle would compress, this little valve would shut, and no blood could get into the aorta.
Oh my
and
goodness.
So they had to keep him on a cardiopulmonary support. And unfortunately, that poor child died 6 weeks later in the arms of his mother.
Oh my goodness.
So, it's
very difficult.
It's very, very difficult, and their suffering was immense. And so I had to take the deposition of the pediatric cardiothoracic surgeon, and I spent 7 hours taking his 7.5 hours taking his deposition. It was a lot of medicine I learned with that case.
Right.
A lot of medicine. So I enjoy the medicine. I enjoy the challenge. It's just makes me feel like I could really do really good things to help people. And that's what really drives me more than anything.
Right. And I think that has been something that I've also learned from you in terms of learning the medicine. And so in your experience in handling these types of cases, do you feel that you have gotten to a point where you can kind of evaluate the cases without having to have the expert in there?
So one of the things that I do is in every case, I get the medical records and I sit down and go through those records. I want to see what's in those records because it's really the evidence in the case on which a claim for medical negligence is, grounded on. If it's not in the records, it likely didn't happen. And so in the course of that, I do learn a lot of medicine. I have to understand why certain things go on and why other things don't.
Right.
And I enjoy that. And once I see that there's something in the record that would support having it evaluated by an expert, that then goes into the next part of the journey. I find the expert, talk to him, get their opinions. And there are cases, and I learned this a long time ago, there are just simple cases that you really can't give an opinion as to whether there's malpractice until you actually have gone through the whole process. An attorney's opinion about medical negligence, if he's not a doctor, that doesn't really help address the question. I can address the question about how difficult it's going to be, how long would it take, what's entailed, that kind of stuff based on my experience. But I usually reserve my opinions until I've done my homework and I've got an opinion from an expert.
Good.
And I recognize that in any given year, there's going to be cases I'm going to look at and evaluate that won't turn into a case.
Sure.
It's just part of what I do. I have to find out. And, a lot of people come see me and they just like, I just want to know what happened. They really, really want to know what happened. It's hard for them to reconcile how things can go bad so quickly.
That's a good point, because I found that a lot of potential clients that call, they don't always discover the issue right away. And so they know that something's wrong, but then they don't quite know what it is and when it occurred. And that can create issues with our statute of limitations here in our state of Florida, right?
Yeah, so let's talk about that. We currently have the law in the state of Florida that the statute of limitations in every case is now 2 years. So if you were in an auto accident a year and a half ago and you don't have an attorney, time is of the essence, because once that period of time passes, all your legal remedies are forever lost.
Absolutely.
And it's really important. And not only that, but time is of the essence for another reason. It's because it's important that critical evidence get preserved.
Right.
And if no one's trying to preserve the evidence or it gets disposed of in an ordinary course of business, that could put you at a very, very serious disadvantage. And that's the kind of thing that is important, where people fall on a commercial property and their surveillance tapes, that those be preserved.
Absolutely.
Because that can certainly show exactly what happened and how it happened. So for medical negligence, the general rule is it's a 2-year statute of limitations, but it can be extended up to 4 years if the patient could not reasonably have discovered medical malpractice occurred.
Okay.
So, sometimes the doctors will tell the patient, I made a mistake. Well, that starts the 2-year period.
Got it.
Other times they're less than candid about what happened and they don't tell the patient. And then the patient doesn't know. And if they couldn't have reasonably have discovered the malpractice, then they have up to 4 years to do it. But my preference on it is that why not file the claim within the 2-year period if at all possible? I don't want to be between the 2 and 4 year period on a case that I have to prove that they reasonably couldn't have discovered that, because it just opens more arguments for the defense attorneys to say, yeah, but you should have known something was wrong, and it just makes it's less than desirable in my opinion.
Right.
So I try to encourage clients, get things done, get an evaluation quickly. And as I said, for medical malpractice cases, there's not a simple button I can push on my desk that's going to perfect this claim in one day.
Exactly.
It's going to take time. I got to get the records. I got to get the expert. I got to do the affidavit. I got to send out the notice of intent. And I have to file suit. It's a lot of work, but something I thoroughly enjoy.
Right.
So.
And I think that gives us a good segue to also give the numbers once again to remind you we are here live in the studio. This is not pre-recorded, so you do have a wealth of knowledge here with Mark Pernick, who can answer your questions about personal injury, namely, of course, medical malpractice is what we're talking about tonight. So once again, that call-in number is 727-441-3000. Again, that's 727 441-3000. If you have any questions in regards to medical malpractice or personal injury in general, we are here to take those calls. We've got some viewers on our Facebook channel. Of course, feel free to comment or ask any question you might have for Mark. So, Mark, before we take a quick break, I did want to ask you about the evaluation process once again. When a case comes into you, I know you mentioned that you like to have the medical doctor, evaluate that. But is there anything else in particular that you're looking for in terms of damages or the result that has occurred, from, the alleged negligence? Is there something that you look at when you're trying to evaluate these cases?
So here's the mental process, if I could share with you. So from my point of view, for a case to be acceptable, you have to have a breach of the prevailing standard of care. That's number
Absolutely.
one. You have to show that the doctor had a duty to do something and either didn't do it or shouldn't have done it. Okay. And then you have to have some resulting injury. Something happened. What happened to the patient? What impact did this have on that person's life?
Exactly.
And so the example I gave of the radiologist who misread the kidney CAT scan was a case only after I learned from the oncologist that there was a window of opportunity before the cancer spread that he would have been a candidate for a liver replacement, which is something that just hiring a radiologist to reread the scan isn't going to answer that question for you. Right. So yeah, here's a breach, but did it cause any damage? And if so, what are the damages? So I had to prove there was something went wrong and there was an injury or damage and there was a cause between the two. Did the breach of the standard of care approximately cause an injury to the patient? Right. And there are times that people will come in and complain about something that happened, but there's no damages that would justify bringing a claim.
Or they're doing better.
Or they're doing better. Yeah. And really, that's really would be my preference, that people just do better. I don't relish in people suffering, and I've seen so much suffering over the years. And, I try to be supportive and help clients deal with that. And, I know when really bad things happen, the only thing anyone gets to do is just choose their attitude. And that's all they have left. And that can make a huge difference in how you're going to live the rest of your life. So if we can choose a good attitude, as difficult as that may be, we'll be better served for that. So that's kind of my philosophy. I've seen clients suffer a lot, and it's unfortunate.
Right. Well, over the years, I'm sure you've seen quite a bit. And of course, I commend you for being a voice of the injured and helping people with their medical malpractice claims. I think that brings us to a good point to do a quick little break here. We are going to take a pause, a quick commercial break, but we will still be here in the studio with Mark Pernick to answer your questions. Again, that call-in number for tonight is 727-441-3000. The lines are free, and we will be back after this break.
This is the TAN Talk Radio Network.
In 1955, the law firm now known as Pernick, Caulfield, Averill, and Noyes made a decision. Instead of taking whatever cases came through their doors, they decided to focus specifically on personal injury. 64 years later, the law firm is one of Clearwater's longest-running personal injury firms. Available 24 hours a day with offices in Clearwater and throughout Tampa Bay, they're ready to put decades of experience to work for you if you or a loved one has been injured in a car accident or injured due to someone's negligence or recklessness. If you feel overwhelmed, uncertain, or unsure about your next steps after being involved in an accident or after a loved one sustained serious injuries due to someone else's negligence, call Pernick, Caulfield, Averill, and Noyes at 727-796-8282 or online at usalaw.com. That's 727-796-8282 or online at usalaw.com. Non-attorney spokesman.
This is the TAN Talk Radio Network.
And we we are back live in the studio with FLA Law on the radio. Hopefully you've been tuned in since the 5 o'clock hour on your drive home. We are here in the studio at WTAN answering your questions live here on the radio. And as you may know, I am here with my partner, Mark Pernick, and we've been discussing medical malpractice law. But of course, we have the lines open to answer any of your personal injury related questions. As Mark mentioned, he's got 39 years of experience to answer your questions, just about anything that you throw at him. I'm sure he can address it. Again, that number is 727-441-3000. If you've had a car accident, a slip and fall, nursing home negligence, we are here to answer those questions, as well as talking about med mal tonight, or medical malpractice. So one thing I wanted to talk to you about, Mark, that kind of came up a little bit before the break, is how personal injury claims could be different as far as in the medical malpractice realm. And I remember in my practice, I had a slip and fall that occurred at a medical facility. And part of what I was trying to determine was this going to be a med mal case, or was this going to be a premise liability case? So I didn't know if you wanted to kind of touch on what differentiates that.
So, that's not that uncommon for people to get hurt in a medical facility. Like, people can fall in a nursing home, going to the bathroom, and they of course have fall precautions that require people to look after them and not allow them to wander from their bed. But then once they fall, then you need to determine, why did they fall? Because if there's a foreign substance on the floor, well, that's the neglect of somebody who should have seen it and had it cleaned up. And that would not be a medical malpractice claim. So for it to be a medical malpractice claim, the injury has to occur as a result of the medical care that was provided.
Right.
So, it's a causation and not just a correlation. Yes, there are cases where an injury was caused by a negligent act, the result of causation. And every time there's causation, there's always a correlation. Those two things go together. But the fact that someone can argue this is just a correlation and was not caused by is an absolute defense to the case.
Right.
So you have to look at these cases with a broader view in mind about what went wrong and why did it go wrong. And again, sometimes we don't know that. Just getting the medical records aren't going to necessarily tell us
exactly
who messed up. And I can tell you that I've had cases against surgeons over the years, and my experience with surgeons is there's oftentimes no malpractice. And why is that? Well, we have an informed consent law that basically says that your doctor has an obligation to talk to you about the risks and benefits of undergoing an operation. And if you have that conversation and he's explained to you all the risk, and you accept those risks, then he's not responsible should something go wrong within those risks. So, for example, we all know that if you have surgery, you could wind up having an infection.
Right.
You could have an injury to a nerve or a blood vessel. Or you could die from anesthesia. And we know all this is true.
Those are known.
Those are all known recognized complications for which the doctor's not responsible. And rightfully so. I mean, honestly, he's trying to evaluate if he can help you.
True.
In his mind, he's weighing the risk and benefits, and he realizes that this is surgery that he thinks you'll benefit from. And you as a patient can say, I don't want to have the surgery. And that's perfectly fair. You don't have to have surgery just because a doctor tells you. But certainly at a minimum, you should ask questions to figure out what is the risk of not having surgery?
Right.
What happens if I don't? How important is the surgery? So, yeah, a lot of times I don't see that many claims against doctors.
So let me ask you, Mark, then.
Surgeons, I should say.
Does that informed consent have to be in writing, or can the doctor simply say, I talked to that patient about it before we did the surgery?
They can, but putting it in writing is the way to prove that you did consent the patient for the surgery. You don't want there to be a question about that. Technically, under the law, if you operate on a patient without their consent, that's under the law is considered a battery, an intentional harmful act.
Yeah.
But there are exceptions to that when a patient shows up at the ER and they're unconscious and something needs to be done to save the patient's life, well, under the Good Samaritan Act, that can be done, and there's not a legal consequence for that. That's good. We want to save people's lives. We want to support life, and we want to do what we can, to help people get better. So the law tries to have a balance between these things. But really, my feeling is that surgeons hardly ever commit malpractice. So.
That's interesting. So then you actually brought my next question that popped into my mind up when you mentioned the emergency room, because it's my understanding that the standard of care is slightly different when you're dealing with an emergency room scenario too, right? Could you explain that to our listeners?
So the concept of negligence, let's define what that is. Negligence is the failure to do or not do something that a reasonable person would have done or not have done. So it's called the reasonable man test. What would a reasonable person have done? Here's an example. I took the deposition of a young girl who was driving her Jeep south on, I want to say 9th Street in St. Pete. It started raining, and she hit the brakes and didn't stop in time and ran into a car that was stopped at a light in front of her. I took her deposition, and I said, is there anything you could have done to have avoided this accident? She says, nothing. There was nothing I could do. I hit the brakes as hard as I could, and I couldn't stop in time because the road was wet. I said, okay, well, and her mother was an attorney, and her mother was the person who rode with her when she had a restricted license.
Okay.
And I knew what the mother was going to say, just being a parent. I took her deposition, and I told her, I said, I took your daughter's deposition, and I said, would you have been able to stop if you had applied your brakes 100 feet further away from where that car was stopped? No.
Sure.
How about 200? No. Was there any number of feet further away you could have applied those brakes and stopped even though it was raining?
She said no.
She said no. She's emphatic. She's like, no, it's absolutely, I couldn't. This is like an unavoidable accident.
Sure.
So I took her mother's deposition, very nice lady, and I said, tell me, you helped her get her license. You rode with her when she had a restricted license. Did you spend any time talking to your daughter about what to do when it's raining? How should you drive differently when it's raining? She said, I did. I said, well, what did you tell her? I said, well, your brakes aren't going to work as good. You have to apply them sooner than later. and I asked her, I said, well,
what do you know?
If your daughter didn't do that, would this accident be her fault? She said, yes.
Wow.
Well, she's a smart enough lady to say, we have insurance. Why are we trying to defend the insurance company where my daughter made an innocent mistake? So a reasonable person would drive with more caution and care. And when the weather restricts your visibility or causes the road to be more slippery, you certainly wouldn't drive faster.
Right.
For sure. And so that's kind of the reasonable man standard. Should you have applied your brakes, avoided a rear-end collision? Should you have? And so when it comes to claims against the emergency room physicians, it's not a reasonable man standard.
Okay.
It's now you have to prove that the physician or the staff in the emergency room acted with reckless disregard, which is a more strict standard under the law than simply a reasonable man standard. And so that's harder to prove because I would think as a general rule, nurses and physicians in emergency rooms don't act recklessly.
Right.
Their main mission is how do we stabilize this patient so they live?
To keep them alive.
Keep them alive. And then if they can get treatment with somebody else to resolve whatever else is going on with them, this is what we need to do.
Sure.
And so over the years since I began practicing in 1984, I've seen a lot of changes that have occurred regarding tort reform. And they still never seem to go away, no matter how much they change the law and make it more restrictive for people to bring claims and enforce their rights to collect damages.
Right.
And so we saw that this year with Governor DeSantis. The legislature passed certain statutes that are just going to make it more difficult to bring claims. He signed it into law. And of course, that appeals to his constituents. But,
sure.
If your constituents are business-minded people, they don't want to have to deal with claims.
Sure.
But for,
But I don't know that this is necessarily going to remedy that.
well, I mean,
That's what they, in theory.
but your constituency isn't just business executives.
Yeah.
It's the citizens who went out to vote for you in office, and why are you turning your back on them? What are you doing to help the little guy?
Right.
What are you doing? And the answer
it'll help their premiums. Is that what they say?
So there was major reform in medical malpractice cases years ago, and it was premised on the concept that OBGYNs were leaving the state because their insurance coverage was way too costly. And it was premised on the idea, if we can pass this, their insurance rates will go down, and we don't run the risk of OBGYN doctors leaving the state of Florida.
Interesting.
And they passed that, and that matter came up for review a few years ago before the Florida Supreme Court. And the Florida Supreme Court determined that the insurance rates never went down.
Surprise, surprise.
Surprise. The rates didn't. They're saving money on the claims. Let there be no mistake about that. But the doctors aren't saving any money on the premiums.
Right.
And that was laid out pretty clear in that case.
Interesting.
It really was. So it's a misnomer to think, oh, this is going to really solve a problem, when a lot of times it doesn't. And that's part of the issue with government.
Mm-hmm.
They don't always have the right solution for the problems they're trying to resolve.
Right.
And so they're going to want to take action that they think is going to resonate well with their constituents.
Absolutely.
They're going to like this. They're going to be happy. We're going to reduce liability for business owners, doctors. And it doesn't always work that way. But what usually does work, it's a detriment to the ordinary citizen.
Exactly. I think you touched on it already, how now the statute of limitations has now been limited and will act to bar quite a bit of claims, I think.
It used to be 4 years, but as of March 28th this year, it's now down to 2.
Now 2, right.
And cases can go away where people, maybe they're treating, maybe they're not really thinking about what are my legal remedies? What should I do to get some advice on
Precisely.
this? And if they don't know about the statute of limitations, they don't contact an attorney in time, there is no case.
Yeah.
And that's not something you can change for them. A court's going to say, here's what the statute says. Here's the date of the accident. Here's when your lawsuit was filed. This case is hereby dismissed.
Exactly.
And your rights are all gone at that point.
I remember I had a claim for an individual. He had surgery, had been treating faithfully for almost 4 years, never called a lawyer, never thought about pursuing the claim until almost kind of the 9th or 11th hour, however the saying goes. And we took the case and we filed the lawsuit. But had he done that now in the 2-year, statute of limitations, he wouldn't have had any case, no remedy for him. The surgery, the medical bills that were outstanding, his lost wage claim, all of that would have been gone. And that's unfortunate that that's what we're kind of looking at now.
It really is unfortunate because the people who don't have the resources, time, or inclination to go talk to an attorney are at a great disadvantage.
Mm-hmm.
And the irony of all that is that when it comes to insurance companies, the underwriting department decides what the premium is going to be based on the risk.
Exactly.
So here's the change in the law that's occurred. My auto insurance premiums haven't gone down. How does this help anyone?
Exactly.
They're saving the money because the risk is much less, but it's not being passed on to the consumer.
Sure.
Even though they're bearing the burden of the changes in the law.
That's what they said about 10 years ago with PIP. They said, oh, it's going to help your premiums. I don't think I saw. If anything, my insurance probably went up after that. So
yeah, it's unfortunate. So, I guess the takeaway tonight is if you have concerns about what happened to you, call our firm.
Absolutely.
We're happy to have you come in. We're happy to talk to you about it. We're happy to spend our resources, get into the bottom of the case with our experience.
Exactly right. I think I talked about this with our other attorney in our office, Lori Robinson, where some individual, she called and thought, maybe I don't have a case anymore now that the law has changed.
She thought it was applied retroactively?
Well, because it was a slip and fall, and she was concerned that she could be found to be more than 51% at fault. So she said, well, I'm not really sure I have a case anymore. And of course, we encouraged her to still give us a call because although that is now the new standard, there could be all kinds of evidence to support that she wasn't, the majority at fault. So I want to get your thoughts on that now that that is the law. If you're 51% or more at fault, you now have to accept 100%
of the burden. So
Exactly.
what the way the law evolved over time was the current law we have is what the law was many, many years ago before the state of Florida adopted what was called comparative negligence.
Mhm.
So originally the law was contributory negligence, and if you were more than 50% at fault, you couldn't get anything.
Exactly.
But with the comparative negligence is that if a jury will apportion the fault between all the parties, and even if the defendant was only 30% comparatively negligent, the client would get 30% of their damages. They wouldn't have to absorb the 70% of the damages they're not getting because they were found to be partly at fault.
Right.
And it was thought that was a more equitable way to administer justice.
Sure.
But they've changed the law, and they've changed it for just one simple reason: we don't care. Honestly, I don't know how else to tell you that. It's you're turning your back on your constituents. You're putting a burden on them, and they're in the most financial vulnerable position
Absolutely.
than anyone.
Absolutely.
I one of the things I appreciated early on in my practice was I came to a realization that people who work in the construction business and they get hurt on the job,
Mm-hmm.
the dominoes start with I've been hurt. I can't work right away, and then I may not be able to work at all. And then what happens then? Well, the next thing, he's getting divorced,
Mm-hmm.
or loses the house. He's getting divorced.
Very true.
He's lost all his children, and it was not his fault for that in the first place. Trying to support a family, pay your bills, is a very difficult thing to do if you haven't had the benefit of education.
Mm-hmm.
And if you're in the construction trade and you get hurt, that's not going to work out too well.
Life-changing.
Very life-changing. The other thing I wanted to share too was I've had cases where terrible things have happened, and I found out there was no insurance. So I had this case. Okay, I had this case years ago. A block mason was putting up a wall on a rural section of the highway in Pasco County, and a woman who was on her way home from a liquor store veered off the road, hit the poor guy.
Oh gosh.
And killed him.
Mm.
And so the woman who caused him to die, she did get prosecuted for vehicular homicide. And that was just fortuitous because a bank employee was following her
Mm-hmm.
and got the license plate. And so when she went to her home, the sheriff showed up, put his hands on the hood and said, "Oh, this car's hot.
Mm-hmm.
This is likely the car." But, he didn't have he didn't have any life insurance. The driver of the car who killed him had no liability coverage. There's nothing. And he and his family didn't have uninsured motorist coverage, which is the last resort for insurance to make a claim.
Right.
It's really critical in a motor vehicle accident. And so here I'm tasked with the responsibility to tell his widow, "I'm sorry, there's nothing I can do for you. There's just nothing I can do for you." And part of the reason that is that we don't have a requirement, and we should, that if you're going to own a car and keep it in the state of Florida, you should have liability insurance. I'm required to have $10,000 property damage, but in case I do damage to another vehicle, so we don't have people driving around the state with dents and damage to the car. So that doesn't look good.
Right.
But I'm not required to have $10,000 of liability insurance should I hurt somebody.
Right.
How can that make any sense to anyone? And
It doesn't.
let me tell you, $10,000 is virtually no insurance, even if you had it, because you could get hurt, go to the emergency room, and you with a CT scan, you could have $8,000 in medical expenses on day one.
Mm-hmm.
So I know you've probably talked about that issue before.
No, and that's good. It's good to remind people about this. I feel like we should talk about it on every show because I'm sure we'd be very rich if we had $1 for every time we've had to explain to people why we can't pursue their case because of the lack of coverage and because they didn't have and how the state does not require it. And people come in all the time and say, "I'm fully covered," right, Mark?
They're not. And,
I've got full coverage.
The real advantage of having uninsured motorist coverage is, yes, it's going to cover claims where the other person had no insurance.
Mm-hmm.
It's going to cover your claim with the person who caused the if they had some insurance, but not enough to cover all your
Exactly.
damages.
Mm-hmm.
And so it's always available, but it's also available should you get injured while walking as a pedestrian.
Mm-hmm.
That coverage will cover you. If the person who caused you to be injured left the scene of the accident and no one knows,
Mm-hmm.
you can at least make a claim for that under your uninsured motorist coverage. And the law
Exactly.
is written in a way that says every insurance agent must offer uninsured motorist coverage. And if the buyer doesn't wish to have it, they have to sign off saying, I reject uninsured
Exactly.
motorist coverage. And
Mhm.
and none of them really get told what impact that's going to have. And so when they come into our offices and we tell them that,
Mm-hmm.
they're like, you got to be kidding. I said, no, we're not kidding.
Yeah.
It's not a good spot to be in. It won't change this case, but you should call your agent and get that coverage going forward.
Immediately. And I always advise our listeners, if you have questions about your insurance policy, you're not sure if you have adequate coverage, you want to make sure that you are covered moving forward, we'd be more than happy to take a look at that for you and see if you've got the right coverages we're talking about. But of course, as Mark mentioned, it's UM and BI. Those are the main coverages that you want to consider.
So UM is uninsured motorist
Mhm.
coverage, and
And then
BI
UIM.
is the bodily
Mhm.
injury coverage.
Exactly.
So I have bodily injury coverage on my car in case I hurt somebody.
Mm-hmm.
At least I have coverage that's going to help honor their claim.
Right.
But I have uninsured motorist coverage on my cars because I know 40% of all drivers in the state of Florida
Exactly.
have no liability coverage.
Exactly.
They're not required to have it, and
Mhm.
therefore they don't. And all they wanted to see is how cheap can I get the insurance,
Right.
not how good the company is. What coverage am I buying?
Sure.
And it's unfortunate, but again, it's a burden to the people who are in a really disadvantaged economic condition to cover their own losses.
That's a good point. So what do you say to people that say, why do I need UM? I have health insurance.
Okay, so uninsured motorist coverage is a little broader than that.
Mm-hmm.
You may have health insurance, and that's good, but it's not. You don't have lost wage insurance.
Right.
So if you lost income or lost your job or lost whatever, the uninsured motorist coverage would cover those economic losses.
Your deductibles, your copays,
Yes,
all those
you know.
expenses. Yeah.
And that would be important,
Mm-hmm.
And so I encourage people to get it. You can't go wrong having it.
Absolutely.
You really can't. It's very important to have.
Get as much
It
as you
is.
can afford. And if you can get stackable, get the stackable coverage.
And what good does health insurance do if your husband dies in an accident? How's that going to help?
Right.
He's dead. I'm suffering. We don't have a source of income. What am I going to do?
Right. Your health insurance is going to pay whatever bill there was.
And that's it.
That's it.
That's right.
So, yeah, I think that's actually absolutely important that we mention it. I think we should on every show. So I think it's been a great show. We've talked about medical malpractice. We've hinted on some other personal injury topics. And so it's a little late to call in. But of course, if you have any questions in these last few minutes, get them in very quickly while the lines are still open, 727-441-3000. But Mark, of course, UM is kind of my always parting word, my word of wisdom. If I had to give one, is there anything that you would want to say to our listeners to encourage them about if you have a personal injury case? This is kind of my advice to you, if you have any.
Well, so I said that we should, the only thing we get to do in life is to choose our attitude.
Mm-hmm.
And, I also choose to live in the state of gratitude.
Yes.
And be grateful for everything I have in my life. I have wonderful children, wonderful grandchildren. I've been very, very blessed. My dad started this firm 68 years ago when Clearwater was a real little town.
Right.
Real little town. In fact, there were no structures on Sand Key back in those days. It was just an open beach.
Right.
And of course, I've seen things change a lot here, living in this area, and I've been very blessed to grow up here. My dad instilled some really good values in us. He was a great leader for the firm. He passed a few years ago, but I couldn't have asked for a kinder, more supportive father than Guy Pernick.
Right.
So I'm very grateful. I'm the most appreciative.
I've only heard wonderful things about your father. Unfortunately, I never had the pleasure of meeting him in person, but of course, we know that he did a wonderful job in the foundation that he laid at the firm. And I've been here all, my entire legal career, and I'm happy to work alongside you and of course, carry on some of the values that your father had.
Well, we're happy to work alongside you, Jacqueline.
Thank you.
You're a great lawyer.
So hopefully you have enjoyed our show this evening. As you know, we are the lawyers at Pernick, Caulfield, Averill, and Noyes. We practice personal injury law. And of course, as you know, that also includes medical malpractice and what we've been discussing tonight. If you want to reach us at our offices, of course, you don't want to call the station number that I've been giving all night. The number to our local Clearwater office is 727-796-8282. And we have offices all over the Tampa Bay area. But our main office is right here in Clearwater, not too far from the station that we're at tonight. We are also online as well. Our website is usalaw.com and voiceoftheinjured.com. We are also on Facebook, as I mentioned, Pernick, Caulfield, Averill, and Noyes Injury Lawyers. The same thing on Twitter and Instagram. We also have a TikTok, so if you're into that, you can find our page on there as well. And if you have any questions that unfortunately you couldn't get in tonight on the radio, we can be reached again at 727-796-8282. And I'm sure Mark will be happy to answer any questions you might have.
So I met a nice woman this morning on a possible medical malpractice case. And I asked her, I said, how did you find the firm? She said, believe it or not, it was TikTok.
Really?
I was like, oh,
well, that is so
that
funny.
Surprising?
Good. It's working then.
Yeah, it must be working. I was like, okay, well.
It's the way we are. The world today is definitely connected through social media. And so if you happen to find us that way, that's wonderful. And tell all your friends and family. If you're watching live, I see we've got a viewer on Facebook, share it with your friends. And hopefully if they have questions, they'll know how to reach out to us. But of course, that is the end of our show tonight, and we will be back here next Tuesday at 5 p.m. to answer your legal questions on FLA Law on the radio. Mark, it was a pleasure having you tonight.
I appreciate being your guest.
Thank you. That's all, folks. Good night.
Good night.